Good morning, ladies and gentlemen, council. This is State of Wisconsin versus Brendan Dassey, 06CF88. Appearances, please.
Good morning, Your Honor. May it please the court, the state continues in its appearance by Special Prosecutors Ken Kratz, Norm Gahn, and Tom Fallon.
Attorney Mark Fremgen appears with Attorney Ray Edelstein. The defendant appears in person.
Are you set to proceed, Mr. Fremgen?
Yes, Judge. At this time, our first witness will be the defendant, but we need the court to proceed with the colloquy with Mr. Dassey to ensure that he is making the decision freely, voluntarily to testify.
All right. If you'd move the microphone over there, Mr. Dassey, can you hear me?
Yes.
It's my understanding you wish to testify.
Yes.
You understand that you have a constitutional right to testify.
Yes.
You have a constitutional right not to testify.
Yes.
Do you understand that decision, whether or not to testify, is for you and you alone to make?
Yes.
That doesn't mean that you can't get advice from family, from friends, from your lawyers, but you understand, in the end, it's your decision.
Yes.
Has anyone made any threats or promises to you in an attempt to influence your decision?
No.
Have you discussed your decision, whether or not to testify, with your lawyers?
Yes.
Have you made a decision as to whether or not you want to testify?
Yeah.
What is that decision?
That I want to.
You want to testify?
Yeah.
All right, let me address counsel. Mr. Fremgen, have you had sufficient opportunity to thoroughly discuss this with your client, the case and his decision whether or not to testify?
I can say for the record that we have spoken at least a half dozen times, specifically on that one issue, and as recently as yesterday.
Are you convinced that he understands the implications of him testifying and not testifying?
I believe so.
Are you satisfied that the decision he announced on the record here is being made knowingly, intelligently, and voluntarily?
I don't know if I can answer that question, Judge.
Well,
I believe I believe he knows what he's doing, and I believe he's voluntarily agreeing to do it.
All right, so it's knowingly and voluntarily being made.
Yes, Judge.
You're suggesting that it's being made by him and him alone in this instance.
That I don't know if I can answer either.
All right, the court will find, based on this record, that the decision of a defendant to testify is being made knowingly and voluntarily. The court has had a colloquy with him. The court believes that the defendant has made this decision, realize it's his alone to make. Before I go through this, counsel,
Give Mr. Fremgen's
reticence,
perhaps the court should inquire of Mr. Dassey if there isn't something else, or if there isn't an explanation for that. Our concern, as you know, Judge, is to make this complete record. If the court is reluctant to do so, I certainly understand that, but that was our
I understand the state's concern. Mr. Fremgen has positively averred that the decision is being made knowingly and voluntarily. I've gone through the colloquy with Mr. Dassey, and I don't know at this stage, absent getting into matters that I have no business inquiring in, I can be doing.
If I can add, Judge,
Go ahead.
you had asked if I thought this was an intelligent decision.
Correct.
And not that intelligence is different viewed from a legal standpoint than common sense. I don't know if I can honestly say that if it's being made based upon reasonable and logical decision making. And the court also inquired as to whether Mr. Dassey has talked to others besides ourselves.
Right.
And I'm sure he has. In fact, I know he has. And For that reason, I can't say for certain that the decision is solely his. I can say to you, to this court, that he has told us that is his decision and he wishes to pursue testifying.
Well, let me then re-ask Mr. Dassey, would you pull a microphone over there? Mr. Dassey, I've told you that in the end this decision is yours and yours alone to make, correct?
Yes.
And you understand that.
Yes.
You've talked to other people about this other than your lawyers?
Yes.
Are you being forced to do this in any way, do you feel?
No.
You're doing this voluntarily.
Yes.
You understand there may be some risk to your testifying,
Yeah.
and you're willing to take those risks in testifying.
Yes.
No one has promised you anything in order to get you to do this.
No.
You're not threatened in any way.
No.
And this is, in the end, it is your decision. Is that correct?
Yes.
That's fine, Judge. Thank you.
Yeah, I don't know where else we can go here, so we'll get the jury in and let's proceed.
There's one other thing, Judge. The as long as the jury is out, I had promised the court and Madam Clerk that there was a videotape clip of an answering machine that I think was on the first day of testimony. That we would have a copy of that made and marked to make part of the record. Over the weekend, we had an opportunity to make a copy of that, and I just wanted to complete the record by providing a copy of that uh, clip as I had promised early on.
Have you previously marked it as an exhibit?
No.
No.
Alright, so this will be exhibit 225.
Yes.
That's all we have, Judge. Thank you.
Alright, specifically, it's a CD of
It's a CD of the answering machine.
Alright,
Clip.
alright, we can bring the jury in then.
So that's received as...
Yeah. Morning, ladies and gentlemen. Be seated. You may proceed.
Judge, at this time, we'll call Brendan Dassey.
Please raise your right hand. Please be seated. Please state your name and spell your last name for the record.
Brendan Dassey. D-A-S-S-E-Y.
Morning, Brendan.
Morning.
How old are you, Brendan?
17.
Where were you living on October 31, 2005?
With my mom.
Where exactly was that located?
At 12930 Avery Road.
What city is that in?
Two Rivers.
And how long have you lived at that address?
6 or 7 years.
Now, there are others that live around you, is that right?
Yes.
Is this all family?
Yes.
Who lived, well, who all lived in that general area?
Me, my family, Stephen, Chucky, my grandma and grandpa,
And who's Chucky?
one of my uncles.
Okay, so it was all family that lived in that area.
Yeah, yes.
Was it adjacent to some property, a business?
Yes.
And what business was that?
The Avery Auto Salvage.
Okay, now you said that Stephen, that's your uncle?
Yes.
And he lived where exactly in relation to your house?
Next door.
About how far next is next door from your house?
A few hundred, 100 or 200 or 300 yards away.
Do you know yards or feet? Do you know the difference between the two?
Not really.
Okay. Was it farther than a football field away from you?
No.
So less than a football field away from you.
Yeah.
Now, who else lived in the house with you and your mom?
Me, my brother, my mom,
You said your brother or brothers?
all three of them.
Okay, and who are they? What are the names?
Bobby, Brian, and Blaine.
So your mom and the four brothers all live there.
Yes.
And how old is Blaine?
10 months older than me.
In in the house, in relation to where you slept, where did he sleep?
In the same room.
You guys shared a room?
Yes.
What about Bobby? How old is Bobby?
3 years older.
And did he also have a bedroom?
Yes.
Did he share with anyone?
No.
And you said Brian also lived there?
Yes.
And where did he how old is Brian?
4 years older.
So you're the youngest?
Yes.
On October 31, 2005, were you attending school?
Yes.
And where did you go to?
Michigan High School.
What level grade were you in?
At the time,
Yes.
10th.
Now, do you know what the difference is between mainstream and non mainstream classes is?
Yes.
Okay. Were you in the mainstream classes at Michigan or non mainstream?
In both.
Okay, so are some of them non mainstream?
Yeah.
It's also, is it also sometimes referred to as special education class?
Yes.
Okay. What kind of grades did you receive when you were in school?
Usually C's, D's, and F's.
Did you belong to any clubs at school?
No.
Any extracurricular activities at school?
No.
Did you work while you were going to school?
Can you repeat that?
Did you work while you were going to school?
No.
So after school, what would you normally do?
Usually play video games.
Where at?
At home.
So on October 31, 2005, was it a normal day for you?
Yes.
And by normal, about what time would you get home? Get home from the school bus?
3:45.
And you did that on that day as well?
Yes.
Was anyone else with you on the bus that day?
Just Blaine.
Is that normal? You and Blaine take the bus together?
Yes.
Where does it drop you off at? Um, does it drop you off at your house?
No.
Where does it drop you off?
By our mailboxes.
Okay. About how far away is that from your house?
About a quarter mile.
How long does it take you to get from where the bus drops you off to get to your house?
Well, if you walk, it takes 5 minutes, but if you run, it probably takes you 2.
Do you normally run home from the bus?
Sometimes.
On October 31, 2005, did you run or walk home?
I don't recall.
Now, did you go directly home from getting off the bus that day?
Yes.
Did you see anyone when you were walking down the bus, from the bus stop to your house,
No.
other than Blaine, right?
Yes.
What did you do when you got home that day?
I played video games.
Do you know what Blaine was doing?
He was on the phone.
Was that something you talked about beforehand?
Yes.
Why would that topic of conversation come up while you were walking from the bus stop?
Because Blaine wanted to use the phone and I wanted to go on the computer.
Did you have one connection in the house?
Yes.
So if someone's on the phone, you can't be on the computer?
Yes.
Do you know why Blaine needed to use the phone?
To call his friend
Do you know why?
to go to see if he was going trick or treating.
So something you guys talked about?
Yes.
You didn't want to go trick or treating that night?
I was deciding if I wanted to.
So now you were at home playing video games. You said this is normal for you.
Yes.
Do you remember what video game you were playing?
I believe it was American Chopper.
How do you recall, or why would you think that that's the game you were playing?
Because some of the games that we have now are too new.
Okay, so that was not a new game at that time.
No.
How long were you playing video games after you got off the bus at 3:45?
About 2 hours.
What did you do after you were done playing video games?
I ate some food.
Okay, did you make it yourself?
Yes.
Where did you go to make food for yourself?
In the kitchen.
How far from your bedroom is that?
20 feet.
Do you know what time it was when you went to make food for yourself?
Around 5.
How do you know it was around 5 when you went to the kitchen?
Because I looked on the oven time for the time.
Okay, was anyone else in the kitchen at that time?
Not that I recall.
Any time while you were eating?
Just Blaine.
Okay, and what was Blaine doing?
He was in the kitchen holding his duffel bag.
Was he going somewhere?
Yeah.
Where was he going?
Trick or treating.
And this is with the same person he talked to on the phone?
Yes.
Do you remember what time he left?
Around 5:20.
So when you say you thought it was 5 o'clock, it was certainly sometime before Blaine left.
Yes.
Was anyone else at home at that time?
Just my mom.
And do you know when the time your mom got home?
Around 5.
Did you see her come home?
No.
How do you know it was around 5?
Because usually she keeps her door shut for her bed to her bedroom.
Okay, but how would you know then it was around 5 when she got home?
She usually comes home from work at that time.
There was no reason for you to, well, strike that. So she normally comes home at 5.
Yes.
Did you speak with her at all, but after or while you were eating supper?
No.
Okay. What did you do after you were done eating?
I went into my mom's room and talked to her about that she was. I asked her, or she told me that she was going with Scott to the hospital to see his mom,
And who's Scott?
my mom's fiance.
Did you know ahead of time that that might be something she was doing that evening?
No.
Okay. Did you learn this was the first time you heard it?
Yes.
Did you see her leave?
Yes.
Do you know what time that was?
Around 5:30.
And was it before or after Blaine left?
After.
Was it shortly after or a long time after Blaine left?
Shortly.
So is that why you think it was about 5:30
Yeah.
when your mom left? Did you see if she drove off in her car?
No.
Did you see how she left? How she left to go up to Green Bay?
Yeah.
And how did that happen?
We got into Scott's truck and they left.
So you saw Scott's truck out there?
Yes.
Now, did you see Scott?
No.
So you're assuming he was driving.
Yeah.
Okay. During the time that you and Blaine had been home after getting off the bus at 3:45, did you ever leave the house?
Can you repeat that?
After you and Blaine got off the bus at 3:45 and before your mom left, excuse me, did you leave the house?
No.
Did you ever see Blaine leave the house?
Just at 5 or around 5:20.
So when he left to go meet his friend was the first time you saw him leave?
Yes.
What did you do? Well, first of all, is anyone left at the house now after your mom leaves?
No.
Do you know where Bobby is?
No.
Did you go in his room to check and see if he was in there?
No.
What did you do after your mom left at 5:30?
Watch the TV
And where do you watch do you watch TV in your room?
in the living room
Do you know how long you watch TV?
until around 6 o'clock when I got phone call.
Who called?
Mike Corneli,
Who's Mike Cornelli?
Blaine's boss.
Do you recognize his voice when he calls?
Yes.
Do you know Mike?
Yes.
Why, how do you know Mike?
Used to work for him.
Did he call for you?
No.
Who did he call for?
For Blaine.
Did you talk to him for very long?
No.
And how long did you talk to Mike?
5 to 10 minutes.
Do you know for certain it was 6 o'clock or around 6 o'clock he called?
Yeah.
And how do you know that for certain?
Because he called after my mom left.
So sometime after 5:30 he called.
Yes.
Okay, and you watched TV for a while before he called?
Yes.
So you're making, would it be fair to say you're just kind of estimating what time he called?
Objection, leading.
Yes.
At this point, I'd ask for more question and answer format.
I think these are fair questions. Go ahead.
Did you receive any other calls after Mike Cornelli called at around 6 o'clock?
No.
What did you do after you got off the phone with Mike?
I watched TV
And how long did you watch TV after you got off the phone with Mike?
until I got another phone call at around 7.
Okay, and who called you at 7?
Steven,
Who's Stephen?
my uncle.
Is it that's Stephen Avery?
Yeah.
Okay, and the one who lives near next door?
Yeah.
What did Stephen call you about?
He asked me if I wanted to come over to the bonfire.
Now, did you look out the window and see if there was a bonfire?
No.
What did you say to Stephen?
That I would be over in a little bit.
So, what did you do? Did you have the phone then?
Yeah.
What'd you do then?
I changed my clothes out of my school clothes
Why did you get changed?
because usually I don't like, I wear different clothes when I go out. Well, I was wearing shorts and short sleeve that day.
What was the weather like that night?
Cold.
So, what did you change into?
Pants and a shirt,
What what kind of pants?
jeans.
Now, you've been obviously sitting through this trial. There were a pair of jeans. I believe it's exhibit number 58. Do you recall seeing that?
Yes.
And those were the jeans you were wearing?
Yes.
Okay. So did you go right over to your uncle's then after you got off the phone?
No.
Or what did you do?
I changed into that clothes, and then he called again about 10 minutes later
Why? Why did he call again?
to see if I changed my mind,
And what did you say?
that I was on my way.
So what did you do next, Brendan?
I walked over there,
Over where?
over by Stephen,
Where exactly did you go over when you left your house at around 7ish?
to the fire pit.
To a fire pit?
Yeah,
Okay. Where's the fire pit located at Stephen's house?
behind his garage.
Did you see the fire going?
Yes,
Could you describe what it looked like?
it was 2 feet high.
Have you seen fires back there before?
Yes,
How often have you seen fires? Do you know?
not that I recall.
More than once?
Yes,
Okay. Did it look like it was a normal sized fire?
yes,
Did you see anything on the fire?
just some tires and some branches.
So, about how close did you get to the fire?
10, 15 feet,
Where was Stephen when you got to the fire?
standing like by the golf cart,
Okay, and where was the golf cart by the fire?
about 15 feet away from it.
All right. What did you do when you got down to the fire?
I asked him what we're going to do, and he told me that he wanted to pick up the yard, and we drove around in the golf cart and picked up stuff,
Okay. What kind of stuff did you pick up?
wood, tires, and an old cabinet, and the van seat.
Now, is this stuff that's just lying around your yard?
Yes,
And by I guess what to clarify, was it your yard or Stephen's yard?
both.
Now we go back to the wood. Do you recall where the wood was on your yard? Where was it?
All over,
Why do you know why there was wood all over your yard?
because it was leftovers from building our garage.
Leftovers from
Building our garage,
what kind of wood?
timber, whatever.
Timber? Wood wood used to frame the garage, you mean?
Yeah,
Okay. You said an old cabinet?
yeah.
And where was that?
Maybe 100 feet away from the our garage.
And some old tires, you said.
Yes,
Okay. And where were the tires when you found them?
in the same place as the cabinet.
So were most of these things on your land?
Yes,
Okay. I'm sorry, did you mention a van seat too?
yes.
Okay, where was that?
On the side of our garage.
Do you know why it was there?
Just that Stephen got it for because we couldn't find one of the seats for the van.
The van, meaning that maroon van that was out in front of your house?
Yes,
Okay. What did you do with the items as you collected them?
we put them in the back of the golf cart.
And what did you do with them after that?
When the back of the golf cart got full, we drove it to the fire.
Did you throw them on the fire?
some of it.
What did you do with the rest?
I piled it or planted it, piled it right by the fire.
How many trips did you take in the golf cart collecting debris from your yard?
Around 4.
And how long did it take you to do that? Collect the debris in your yard?
About 45 minutes.
And after that, what did you do?
Went into the garage. Stephen asked me to help him clean up something in the garage on the floor.
Okay. Now, have you been in the garage before?
Yes.
Had you ever worked with Stephen before in the garage?
Yes.
Was it unusual for him to ask you to help you clean something out of the garage?
Not really.
What did that, you said it, something to clean up. What was the something? Do you know?
No.
What did it look like?
Looked like some fluid from a car.
So, what did you do to clean up, or how did you clean up the mess on the floor?
We used gas, paint thinner, and bleach with old clothes that me and my brothers don't fit in.
Okay, well, let me ask you, was it a large spill?
About 3 feet by 3 feet.
And did you pour gasoline on it?
No.
So you were, what, what did you do? If you weren't pouring the gasoline, what were you doing to help clean up?
I was looking through the bag to find stuff to clean it up with.
Bag of what?
Bag of the clothes.
And did you clean it up with something from the bag of old clothes?
Yes.
Okay, and as you did that, what did you do with the rags? Did you just wash them out?
What do you mean?
When you cleaned up with the old clothes, what did you do with them as they got dirty?
Oh, we picked them up and we threw them on the fire.
Okay, now you said that you used three items to try to clean up the mess on the floor.
Yes.
And did you ever pour anything on the mess?
No.
Okay. What was the second item that Stephen used?
Paint thinner.
And did that clean up the mess?
A little bit.
Same thing. Used rags then to clean up?
Yes.
How would you how did you do that? Did you get down on your hands and knees? Can you explain how you did that?
Oh, we would just throw it on the floor and we used our feet.
And then you would do what with them?
Move them around.
And then what did you do with them after they were dirty?
And picked them up and threw them on the fire.
And how did you pick them up?
By our fingers.
The bleach. That last?
Yeah.
Where did Stephen get the bleach?
From the house.
Did you go in with him?
No.
Did you ever go in the house that night?
Not that I recall.
His house?
No.
Do you know where Stephen keeps his bleach?
Usually in the bathroom.
And how do you know that?
Because I was in the bathroom a few times and I seen it.
Can you estimate in the past how many times you've been in the bathroom?
20 to 25.
So you're familiar with his house a little bit.
Yes.
Did you ever ask Stephen what it was that was on the floor?
No.
Now, do you recall at some point from February 27th or on 2006 speaking to investigators Wiegert or Fassbender?
Yes.
And you recognize them, right?
Yeah.
They're here in court?
Yes.
Okay, and you spoke to them a couple times?
Yes.
Did you tell them what you saw on the floor?
Yes.
What did you tell them?
That it could have been blood.
What did you tell them the first time they asked you what it was on the floor?
Can't remember.
How long did it take you to clean up what was on the floor?
15 minutes.
Now, did anything happen to your clothes cleaning up the mess on the floor?
Not that I noticed right away.
What did you notice later?
That there were bleach stains on them.
Bleach on what?
The pants.
Okay. Did you ever wear those pants again?
Not that I remember.
What did you do with them?
I washed them that night and just put them in my dresser.
So, after you finished cleaning up, you said it took about 15 minutes.
Yes.
And what did you do then?
We went back outside and we put some of the more of the stuff that we picked up from the yard.
How close to the fire did you get when you were throwing more stuff onto it?
About 5 feet.
Did you yourself get any phone calls while you were out there?
Not that I talked to.
Did that, so someone call you,
My mom called Stephen.
but you didn't talk to her?
No,
Do you know what time that was?
not that I recall.
Did did he tell you what she said to him?
Yeah.
Was Stephen outside with you the whole time watching the fire?
Yes.
Other than going in to get the bleach, did he ever go inside?
No.
So now you're watching the fire for a while, right?
Yes.
What are you doing?
I only can recall that Stephen was talking to me about a phone call that he got from Jody.
Okay. Do you recall any other conversations you had?
Not that I recall.
Did you, but you were talking?
Yes.
Do you know how long you were out there waiting and, or, excuse me, talking and watching the fire?
No.
About what time did you go home?
Around 10.
Do you recall? And again, maybe I asked you this. I'm sorry. Did I asked you what time you received the call from your mom?
Yeah.
Did you know what time that was?
No.
Okay. When you got home, was anyone else home?
Not that I recall.
Did you see any brothers?
No.
Did you talk to your mom at all?
Yeah.
When was that?
About 10:20.
Was she home then?
No.
How did you talk to her?
He called on the house phone,
What were you doing when she called?
sitting on the couch.
What time did you go to bed?
After I got done talking to my mom.
Now, following October 31st, 2005, did you lose any weight?
Yes.
How much did you lose?
5, 10 pounds.
Were you doing this on purpose? Is it
No.
you weren't trying to lose weight?
Well, I was trying to.
Okay. Why were you trying to lose weight?
Because people were calling me fat, and because I thought that girlfriend broke up with me because of my weight.
You mean first ever or
Yeah.
prior to October? Or, well, let me actually, ask you it this way. Have you ever seen Teresa Halbach before?
No.
Now, you obviously know that name, correct?
Yes.
When was the first time that you recall hearing that name or seeing her picture?
When she was reported missing.
When was that? Do you recall?
Not that I remember.
And how did you come about hearing about her being missing?
On that day, my mom called. She told me to turn on the news.
So you watch TV?
Yes,
Now, at some point, your Uncle Stephen is arrested, correct?
yes,
Did you watch any TV accounts about that?
not that I remember.
Did you ever see Teresa Halbach alive on October 31 of 2005?
No,
Did you ever see her body that night?
no,
Now, you spoke with investigators Wiegert and investigator Fassbender, correct?
yes,
And you were in court for the video as well, correct?
yes,
Obviously, that's you on the video, right?
yes,
Do you realize how serious this charge is?
yes.
Why did you tell those two investigators that you participated in killing and raping Teresa Halbach?
I don't know.
You have no idea why you would say that?
No,
Okay. Brendan, I want to talk about that video a little bit with you, okay?
okay,
You you know it was being videotaped that day,
yes,
and the officers explained to you your rights. Is that right?
yes,
Did you understand them?
yes,
When you first talked to the officers about Teresa Halbach, did you immediately tell them that you were there and participated in killing and raping her?
no,
In your mind, Brendan, do you feel as if there were promises made to you by the officers?
sort of.
What do you mean by that?
That if I told the truth, that I won't go away for life.
Did you tell the truth?
No,
What other promises do you think, in your mind, what other promises were made to you?
that's all I recall.
There were times that they wanted to talk to you about a gun, right?
Yes,
And did you ever admit to using the gun?
no,
Why didn't you admit to that?
because I don't like guns.
Was that different than it when you admitted to what you're saying you didn't do?
Yes,
Why is that? Why do you believe that's different?
I don't know.
When you were being questioned by the two investigators, did they ever tell you that they were telling you the truth about things?
Did I feel like that?
No, did they? Did they tell you that?
No.
Did they ever say they were lying about anything?
Did they say I was lying?
No. Did they say they were lying to you?
No,
You don't know what they were telling you was true or not, correct?
Objection, leading at this point.
Under 961.113, some leading questions are permissible, mainly foundational questions. We are now getting into some evidentiary areas, so I'm going to sustain the objection.
That's fine. I was essentially using that to try to lead up to this question, which will be a little more open ended. If you didn't know that they were lying to you or telling you the truth, Brendan, why did you answer the questions to them the way you did?
I don't know.
Do you have any explanation for admitting to this?
No,
How many times did you talk to the officers before March 1?
twice
And when did those two times occur?
in November of 2005.
How many times in November?
Twice.
Okay. What about any time between November 2005 and March 1st, 2006?
To March?
Between those two dates, did you talk to the investigators? Investigators Uyghur or Fassbender?
Yes.
And how many times did you talk to them before those two dates?
Once
Between
in
those two dates, sorry.
once in February, or there was 3 times on February 27 and one on February or March 1.
So where were the 3 times in February? Where did those occur?
One at school, one in Two Rivers, and one, I believe, it was the fire department in Michigan.
What happened after they spoke to you on February 27? Did they arrest you?
No,
What happened to you? Where did you go?
they put us up in Fox Hills Resort.
Okay. How long were you up there?
We only stayed up there for that night,
Which night? What's the date of that?
February 27.
Where did you go on February 28?
Home,
Where did you sleep on February 28?
at home.
Where did you go on March 1st?
Went to school.
And after that?
The investigators talked to me and first they brought me to my house to get the pens, and then they brought me to Manitowoc.
I have nothing else, Judge.
Cross?
Yes, thank you. Mr. Dassey, a few questions for you. All right.
Okay,
First, let me ask you this. How long does it take you to walk from the trailer where you were living with your mom and your brothers to your Uncle Stephen Avery's trailer?
around a minute or two.
All right. You like to play video games, right?
Yes,
As a matter of fact, when you got done with school, you would like to design video games?
yes,
You really enjoy working with them,
yes,
and you're pretty good with them.
yes.
All right. And at school, you have just 2 special classes, right?
I don't know.
Well, you said you had both mainstream and some special classes.
Yes, but I don't know the names of the.
How many special classes did you have? 2, right?
That I recall. Yeah,
Okay. Otherwise, you're in with the rest of the regular students, right?
yes,
Okay. Now, let me show you something. Exhibit 58. Do you recognize these?
yes,
All right. These are the blue jeans that you were wearing on the night of October 31.
yes,
All right. And these are the ones that you just told your attorney that on March 1, you went with Special Agent Fassbender to pick these up on your way to the sheriff's department.
yes,
Okay. These are your pants. These are the pants.
yes.
All right. You're telling us you washed them that night?
Yes.
Did you wash anything else that night?
Not that I recall.
Just those pants.
Yes.
All right. Now, you just told us that you were cleaning up the floor in the garage,
Yes.
but you didn't get on your hands and knees to clean the floor.
No.
Okay. In other words, you just put whatever cleaner down and you used your feet to mop up the stuff with the old clothes.
Yes.
Is that right?
Yes.
Okay. You're sure?
Yes.
Okay. And you just told us that the pants didn't seem to get dirty. You didn't notice them being dirty.
Yeah.
And you had just put them on before you went over there.
Yes.
Okay. Where did you get them from when you changed your clothes?
In my dresser.
In your dresser drawer?
Yes.
Were they clean then when you put them on?
Yes.
All right. If they were clean when you put them on and you didn't notice getting them dirty and you never got on your hands and knees, why did you wash them?
Because I usually do after a while.
You usually wash your pants after wearing them for 2 hours?
Well, I usually wash pants for school every day almost.
You do laundry every night?
Yes.
Mr. Dassey, you went over to your Uncle Stephen's house at some point after school.
No,
You didn't tell your mother that went over there?
I didn't.
All right. Well, then play something. Let me play something for you, and I want to ask you a couple of questions, all right?
Okay.
That was a conversation between you and your mother, right?
Yes.
All right. Why didn't you tell your mother at 5 that what you had seen earlier?
Because it really didn't happen.
Was Teresa alive at 5, Mr. Dassey?
She was never there at when I was there.
Never where, sir?
I never seen her there.
You never saw her there?
No,
All right. Then why is your mother asking you that question?
I don't know.
What do you think she would have gotten the idea that you were there before 5 o'clock, sir?
I don't know.
She came home about 5.
Yes.
So at 5, you're home, your brother, Blaine, is still there, and you're there.
Yes.
Your brother, Blaine, leaves at 5:15, 5:20.
Yes.
Your mother leaves at 5:20, 5:30,
Yes.
and she leaves with Mr. Taddick.
Yes.
All right. Mr. Dassey, let me ask you a question. In the interview you gave on March 1 with these two gentlemen here, you told them that your uncle's fiance, Joriz Stokowski, called, correct?
Yes.
You told him that she called twice, correct?
Yes.
You told them that she called at 5:30?
Yes.
How do you know that if you weren't there?
Because Stephen told me.
He told you that?
Yes.
What time did he tell you the other time?
What do you mean?
I'm sorry?
What do you mean?
How many times did she call that night?
Twice.
And how many times were you there?
When I was there?
Yeah.
Once.
I have something else I'd like you to listen to, sir. I have something else for you, sir. One moment. Record should reflect that was about 14 minutes.
Do you have the start and ending times?
Yes, 11:37, 47 to, I believe it was about 11:50 approximately. All right. Mr. Dassey, you told the officers that you were there and Teresa was alive.
Yes.
She was alive.
But it really didn't happen.
You made that all up.
Yes.
You just happen to know Teresa's words.
No.
How do you know what she said?
I made it up.
You made it up?
Yes.
You made up the part that you raped her?
Yes.
You made up the part where she told you not to do it,
Yes.
to do the right thing,
Yeah.
and to tell your uncle not to do it.
Yes.
You made that up.
Yes.
Now, Mr. Dassey, didn't you tell your mother in the phone call on May 13 that you had gone over to your Uncle Stephen's after school and before she came home?
Yes.
You did?
Yes.
Again and again on May 15, the first tape we played, she's asking you, why didn't you tell her? Why didn't you?
Because it didn't happen.
Why did you tell her you went over there, sir?
I don't know.
You lied to your mother as well?
Yes.
And you lied to the police.
Yes.
Are you lying? Are you lying today?
No.
Did you tell your mother when she asked you, When did you go over there? Well, I went over earlier and then came home before you did.
Yeah.
You told her that, right?
Yeah.
All right. And she said, "Why didn't you say something to me then?" Right?
Yeah.
And you answered, "I don't know. I was too scared."
Yeah.
You didn't tell your mother you weren't there, did you?
Because I never went out over there.
My question, young man, is you didn't tell your mom you weren't there, right?
No,
That's not right.
I didn't tell her
You did not. Why?
because I didn't go over there.
Why did you let her believe that you did?
I don't know.
Now, speaking of these lies, Mr. Dassey, on your direct examination, you told us that there was a fire that night, right?
Yes.
But when you were interviewed by F. and Cribitz by Detective O'Neill, you remember the gentleman who testified a couple of days ago?
Yes.
All right. You told him that there was no fire that week, right?
Yes.
So you lied to him.
Yes.
Why did you lie to him?
Because I'm just like my family. I don't like cops.
You don't like cops? Why didn't you tell Detective O'Neill what you told us on direct examination today?
I don't know.
You didn't. If you didn't do anything wrong, sir, why didn't you tell Detective O'Neill?
I don't know.
Your brother's interview was done much more quickly than yours, right?
Yeah.
On November 6th.
Yes.
In fact, he was done in about 10 minutes, maybe 15, maybe.
I believe so.
All right. Now, in that second interview, you just told us that you were interviewed twice up in the Cribitz area. On the second interview, you did tell them about a fire.
Yes.
When did you tell them the fire happened that time?
On October 31st.
Isn't it a fact that you told them that the fire was on Tuesday or Wednesday of that week, not Monday?
I might have.
I want to play one very brief clip from the March 1 interview, sir. I'd like you to watch it and then answer a question or two. All right?
Yes.
For the record, I started at 2 hours, 10 minutes, 25 seconds to Mr. Dassey, if you didn't do anything, why did you feel sad?
I don't know.
Why did you apologize?
I don't know.
They didn't tell you to apologize.
No.
You apologized on your own, right?
Yes.
You always apologize for things that you didn't do.
Not really.
In fact, you usually apologize when you've done something wrong.
Not really.
You don't apologize then either?
Sometimes.
Okay. When do you apologize?
For both.
For both? Explain, please.
I would say that I'm sorry for some things I do and some I don't.
Is that why your apology in this case, because you were sorry for what you had done to Teresa?
No, because I didn't do it.
Why did you apologize?
I don't know.
Well, now, all week you sat in court with your head down and you didn't look at the tape of the interview when we played it on Friday. Why?
Huh?
Why did you not look at the tape?
Because I didn't have to.
In fact, you didn't look at the tape this morning. Then, when I played it for the fifth, for almost 15 minutes, did you?
No.
You didn't have to, right?
No.
That's because you knew what was on it.
Yes.
Yeah. Are you ashamed of your behavior? Is that why your head is down all week?
No.
Are you feeling guilty?
No.
Then why are you hanging your head all week?
I had my head down because I can hear better that way.
Are you hearing me all right now?
Yes.
You've heard Detective Wiegert testify on
Yes.
Friday and Saturday morning, right?
Yes.
And he said that he had no idea that there was a sexual assault.
Yes.
You were the one who brought up the fact of a sexual assault, right?
Yes.
You brought up the rape, right?
Yes.
You went over to your uncle's cabin because you knew you were going to have sex, right?
No.
Why did you tell the police that your Uncle Stephen was proud of you for what you had done?
I don't know.
Why did you say that you sexually assaulted her?
I don't know.
Why did you say you put your penis in her for 5 minutes?
I don't know.
Why did you tell the police that you thought it was blood in the garage?
Because it was the color of red.
Because it was the color of red?
Yeah.
It looked like blood?
It could have been.
What else could it have been? Would it have been?
Fluid from a car.
Mr. Dassey, have you ever used bleach to clean up car fluid?
That was the first time I cleaned up car fluid.
First time?
Yes.
All right. And you used gas?
Yes.
Used paint thinner?
Yes.
And you used bleach?
Yes.
You used the bleach.
Well, Stephen put it on the ground.
How did the bleach get on your pants if you never got on the ground, sir?
It could have splashed up on my pants.
All the way up to your waist?
That or I could have had some sprinkles on the bottom. Could have been from splashing on the ground, and when I picked up the towel, the rags that we used, I could have wiped off my hands on my pants.
Those rags were Teresa's clothing, right?
No.
Why did you tell the officers her clothing was in the fire?
I don't know.
All right. I want to show you a picture. I'm showing you what is marked for identification or received into evidence, as Exhibit 204. You recognize that the people in that picture?
Yes.
It's your Uncle Steve on the right?
Yes.
And your grandma and your grandpa in the middle,
Yes.
and that's you on the left.
Yes.
And that's at the cabin in Cribbets.
Yes.
As a matter of fact, that's the search warrant on the table, right?
I can't tell.
Do you remember that picture being taken?
Yes.
And it was taken right around the time that you were interviewed by Detective O'Neill, right?
I can't recall.
Well, you just said you remember when the picture was taken. When was it taken?
In November something.
In November?
Yes.
While you were up at Cribbets?
Yes.
And before your Uncle Steve was arrested.
Yes.
So it would have been taken between November 5 and, say, November 9.
Yes.
What were you talking about in that, right around that time of that picture?
I can't remember.
All right. Is your Uncle Stephen proud of you? Does he have that proud look in his face?
No.
What are you thinking in that picture? Do you remember?
No.
Why did you tell the police that your Uncle Stephen was proud of you for helping him?
I don't know.
Why did you tell them he couldn't have done it without you on that March 1 interview?
I don't know.
Well, he was proud of you for helping him, wasn't he?
No.
He was not?
Because it didn't happen.
I'm sorry. What didn't happen?
All the stuff that I said.
Well, did you clean up?
Yeah.
All right. You helped put things in the fire.
Yes.
All right. As a matter of fact, you saw this car seat, right?
Yes.
It's sitting right in front of you, right?
Yes.
You helped your uncle put that car seat on the fire,
Yes.
and you helped him put towers on the fire.
Yes.
So that part's true.
Yes.
And he told you when he was done, "Thanks for helping. I'm proud of you. I couldn't have done it without you."
Not that I remember.
Well, let's talk about your memory. How is it that you're able to tell the police officers, Mr. Fassbender and Mr. Wiegert, so much detail about what happened to Teresa if you weren't there?
I don't know.
What do you mean, sir? You don't know.
I could have got it out of books.
Out of books?
Yeah.
Tell us, what book could you have gotten that out of?
I don't remember the names.
Where else could you have gotten it?
I don't know.
All right, out of books. Let's talk about that then. Would you say you have a good memory, Mr. Dassey, or a medium one, or a poor one?
Between poor and medium.
All right. And would you agree with the counselor, Ms. Gross, Schonenberger Gross, when she testified on Saturday morning that you do have memory problems when it comes to learning stuff at school?
Yes.
As a matter of fact, when you read things or when teachers tell you things, it's hard for you to remember that so you do well on your test, right?
Yes.
All right. But for other things, things that you personally experience, things that you see and feel and hear and smell yourself, your memory is better for those things, right?
Somewhat.
And and that's because you actually live through them. You experience them, right?
Yeah.
Well, when was it that you read books to help provide all that detail to these officers?
Probably 3, 4 years ago.
I'm sorry?
3 or 4 years ago.
3 or 4 years ago? And you just happen to remember all that on March 1, 2006?
Yes.
And you just happen to be able to tell them the exact deep travels of your Uncle Stephen took in driving Teresa Halbach's SUV from his garage to the place in salvage yard where the vehicle was hidden?
Yes.
What book had that story in it, Mr. Dassey?
I don't know.
What book that you read ever had the story of a woman chained to a bed, raped by two, raped, stabbed, and then her body thrown on a fire? What book was that, sir?
I believe it was called Kiss the Girls.
All right. Who wrote the book?
I don't remember his name.
Mr. Dassey, please look at Exhibit 208.
Yeah.
You drew that, correct?
Yes.
That's your depiction.
Yes.
Teresa Halbach chained to the bed?
I don't understand.
Is that your description? Is that how she looked when you saw her on the bed in Uncle Stephen's bedroom?
I didn't see it.
You just made it up?
As I said, I got it out of that book.
Yeah. The bed is a bed that you could see from the living room. You could see down the hallway and see into the bedroom.
Yes.
Exhibit 210. You drew this as well, sir, correct?
Yes.
That is your description of the burn area.
Yes.
That is your description of Teresa on the fire in the burn pit.
Yes.
You made that up?
Yes.
Why?
I don't know.
Did you make Exhibit 208 up?
Yes.
Why?
I don't know.
Exhibit 209, you drew this picture of the garage, correct?
Yes.
This is your picture of Teresa Halbach, right?
Yes.
And that's the area right here where you cleaned up, right?
No.
Well, you said that you cleaned up a 3 foot by 3 foot stain in the garage on direct examination, right?
It was in the garage, but not right there.
You told the police it was right behind the lawnmower,
Yes.
and that's where you cleaned up.
No.
Why did you tell the police that this was the area of the cleanup?
I don't know.
Why did you put Teresa Halbach's representation, the stick person? Why did you tell them that this was Teresa's body?
I don't know.
Exhibit 207, you drew this picture of the knife.
Yes.
You said this was the knife that your uncle Stephen used to stab Teresa Halbach.
Yes.
You drew that,
Yes.
and you describe it as having a black handle.
Yes.
And you told the police that this was the knife that you used to cut across the front of her throat.
Yes.
Why?
I don't know.
Mr. Dassey, why did you tell the police that the burn pile smelled bad?
I don't know.
It smelled bad because there was a body there, right?
No.
You saw body parts in that fire, didn't you?
No.
You told the officers that on February 27th, you saw body parts.
Yes.
You told your cousin Kayla you saw body parts in December.
No.
No, she just made that up.
Yes.
Okay. Did you ever talk to Kayla about the events, the things that happened on October 31?
Might have talked about Stephen to her, but not what happened on that day.
What would you think you would have told her about Stephen?
I don't remember what I told her.
Did you tell her anything about body parts or any of the information that you told the investigators, Fassbender and Wiegert?
No.
Okay, you're sure?
Yes.
Absolutely sure.
Yes.
Okay. Then tell us, how is it that you and Caleb both came up with the telling and seeing the body parts in the fire if you never talked about it?
She could have heard it on the news.
What newscast would have that been, sir?
I don't know.
You're seeing body parts in the fire. What newscast was that?
I don't know. When I heard that they found bones.
No, my question is, you told the police on February 27 you saw body parts, right?
Yes.
All right. Kayla is telling her counselors of a conversation that she had with you. She's telling her counselors in January that she talked with you in December and that you had told her about body parts. How could that be?
I don't know.
How do you feel about this today, right now?
Did I just want to go home?
That's how you feel right now? You just want to go home?
And scared?
You feel sorry for Teresa?
Well, I know everybody feels sorry for losing someone.
What do you feel?
I feel sorry for them
Why? Why?
because I know how it feels to lose someone that you love.
And you're telling us today that you had nothing to do with the death of Teresa Halbach.
No.
Why did you tell the officers that you did?
I don't know.
And is it just a coincidence that you had all the details about how she died?
I don't know.
Do you recognize this exhibit 170?
Yes.
This is a rake that your Uncle Stephen used to attend the fire that night, isn't it?
I can't remember.
You can't remember?
No.
How about this shovel, Exhibit 171?
Yes.
He used this shovel that night, right?
Well, I know he used a shovel and a rake, but I don't know that they're it.
How did you know that Teresa was handcuffed to the bed?
I don't know.
You just made that up?
Yes.
You've never told a lie before that got you into so much trouble, have you?
No.
That's all.
Redirect.
Brendan, you have been asked by Attorney Fallon about the genes, and specifically asked about how bleach got on them, correct?
Yes.
You said you might have wiped your hands on them.
Yeah.
Do you recall wiping your hands on them?
I think I did.
When did you notice that they were dirty with bleach?
When I got home.
That same night?
Yes.
Mr. Fallon played a portion of the video for you to watch and asked you some questions. Do you recall that?
Yes.
And he questioned you about how you had answered the questions to the two officers, correct?
Yes.
Had you said the same thing before that to the officers?
Objection, beg.
That's fine. What did you say to the officers about those same topics prior to that clip that he just showed you?
I don't understand.
Okay. Attorney Fallon showed you a clip of you telling the officers about being there and seeing Teresa Halbach and participating and killing her and sexually assaulting her, correct?
Yes.
You watched that or saw it or heard it.
Yes.
Were you asked those same questions at any other time during that interview?
During that interview?
During interviews with the officers?
Before the taping?
Were you asked any questions like that before that clip on the video?
Yes.
Were your answers the same?
No.
Why did you have different answers before that?
Because I was making it up.
What were you making up?
The details in that?
Before or during the clip that Mr. Fallon showed, what was the part that you made up?
Well, the stuff that didn't really happen is the stuff that I made up.
And what stuff didn't really happen?
Where I was over there before 5, where I helped and kill her and rape her and that.
Why should this jury believe you today?
Because I really didn't do it.
On the video clip, again, I'm talking about the one Mr. Fallon showed you,
Yes.
the longer one.
Yeah.
It's about 15 minutes long. You heard the questions that were asked of you by the officers.
Yes.
When the officers would tell you that it wasn't your fault, how did that make you feel when you're answering the questions?
Objection, beyond the scope.
It was on the video.
It was overruled. You may answer.
Can
you repeat that question?
When the officers would tell you this is not your fault, how did that question or how did that comment in the question make you feel?
That I wouldn't be taken away from my family and put in jail.
No matter what you said?
Yeah.
I have nothing else, Judge.
Any recross.
No, thank you.
All right, you may step down. We'll take a break until about 1:45. At this stage, ladies and gentlemen, this is a part of a defense case. The defense has subpoenaed a witness, but the witness is not going to be available until 1:30 this afternoon. Is that correct?
He's apparently leaving the crime lab shortly. Should be here by 1:30.
You're finding out that scheduling witnesses is certainly not a science in the case. I'm not even sure it's an art, but in any event, that's what occurred. or that's what is occurring at this stage. And he will be your only witness this afternoon?
This afternoon. The next witness we have would take about, we're guessing, somewhere between 5.5 hours.
Tomorrow.
We'll begin for Monday, tomorrow morning, correct?
All right, so with that said, we're going to adjourn until 1:30 this afternoon. Thank you. Mr. Fremgen.
Judge, at this time, we would call Mike Riddle.
Right up here, sir. Just remain standing.
Please raise your right hand. Please be seated. Please state your name and spell your last name for the record.
Michael Riddle, Riddle.
Mr. Riddle, what is your current employer?
I'm a latent print examiner with the State Crime Lab in Madison.
Why don't you pull the microphone just a little bit closer to you? And how long have you been working in that capacity?
Be 15 years in August.
What generally are your duties and responsibilities as a fingerprint analyst for the crime lab?
We receive evidence from local sheriff and police departments to process for presence of latent finger or palm prints. If we do get prints on any items and they're compared to standard fingerprint or palm print cards in attempt to make an identification.
You've testified as an expert in fingerprint analysis in prior cases in the state of Wisconsin.
Yes, I have.
I believe at this time, Judge, the state has no objection to qualifying this individual as an expert in this field.
Is that correct?
That's correct, Your Honor.
All right, it's stipulated then.
We'll avoid a number of other questions that way. I see you have a file with you. Is that the file in regards to this investigation?
Yes, it is.
If you need to refer to that while you're testifying, if you can just indicate that you need to do so before you do.
Okay, thanks.
Thank you. Can you briefly explain why analyzing fingerprints is an important investigative tool?
Because of the uniqueness and individualness of fingers, no two fingerprints are alike on any person or persons. So if we are able to find a latent print on an item, it does indicate that the item was touched at some point in the time by that particular individual, to the exclusion of all others.
Now, is this an exact science?
Yes, it is.
Can you briefly describe what it is that you're looking for as a fingerprint analyst when you're doing a fingerprint analysis in regards to, say, comparing a known fingerprint to an unknown fingerprint?
Well, the first thing I do is if you can see a pattern type, there's only three basic patterns on fingerprints, and it's a whirl and a loop or an arch. Looking at the standard, if I see that a person has all loops, which is fairly common, and the latent fingerprint I have is a whirl, then I don't have to look any further. I can automatically exclude that print. If I do get two pattern types that are the same, then I look for individual characteristics within that pattern area in order to make an identification.
What ways do you, let's say, a crime tech individual who may be lifting prints, and you can describe what that means, but what ways are there available to you or those persons extracting or developing a fingerprint for purposes of comparison? Can you describe the ways that you go about to do that, please?
There's several different ways, and usually it depends upon the nature of the surface as to what method of development we use to bring out the fingerprint. A A latent print is also called a hidden print, which means it's invisible and has to be brought out or developed by the use of powders or chemicals. If we have a real nice smooth surface, such as a piece of glass, then you can just use regular fingerprint powders, develop the print that way. And we can photograph it and preserve it. And either do or do not lift it. It depends. If you have it captured with a photograph, there you really isn't it isn't necessary to go any further. But many times we put some lifting tape, which is like a clip tape, and we'll rub it on the top of the print, pack it up, and put it on a backer. If we're using if we're using white powder, we'll can put it on a black backer so that you can see the contrast. And if you're using a dark powder, then we'll put it on a white or a clear backer so you can see it. Other items that are more porous, such as paper, cardboard, we have to use chemicals in order to develop those prints. There's one particular chemical we use called
Yeah.
nenhydrin, and it reacts to amino acids in the fingerprints. So we use when we process that, either brush it on or spray it on. It de- it'll develop kind of a purple fingerprint, brings it out to the ridge detail. There's also super glue, which we use on semi-porous items. Put it in the tank where there's super glue fumes, and the fumes will adhere to the fatty acids in the fingerprint. After that's accomplished, we can either powder it and lift it, or we can enhance it further by using a dye stains and look at it under a laser.
No, you were referring to latent prints
Yes,
for the most part.
that's correct.
There are other types of prints, correct? For instance, visible prints.
There's visible prints known as patent prints, and they're also ink impressions. We get from other fingerprint standards, like on a fingerprint card.
What are plastic prints? Have you heard that term before?
Yes, it's either a plastic or a molded impression, and these are impressions that might be live, left on in clay, putty. Oftentimes, if a burglar tries to get through a window, it's puttied. We can find molded prints inside there.
Now, if someone leaves a print in dust, for instance, what would that be able to be lifted under some of the what you discussed in regards to latent prints, or is that more appropriate to be somehow preserved as like a plastic print?
Well, in a dust print, we don't get a whole lot of those because what normally happens if a surface is really dusty and that hand or fingers touch that dust item, it lifts the dust away, and it may leave an impression looking like a finger was there, but there's usually no ridge detail at all. So not much we can do with that. We can try super gluing it and see if we can develop ridge detail, but on dusty surfaces, it usually doesn't work very well.
Is it possible to use digital photograph of a print, whether it be visible or plastic, for instance, to be able to preserve the print without actually physically touching the print?
Yes, it's possible. We use standard 3 by 5 format film, not digital. to capture our prints. Although we do get many prints in from other agencies that we've used digital camera to take them.
For instance, the FBI, I think, has developed a methodology and for that technology for extracting prints using digital photographs. Is that correct?
Yes, that's correct.
Now, and in this case, you were called in at some point to assist in the investigation, the Halbach case,
Yes, I was.
and you'd have, well, how would it occur? Did the lead investigators contact you and ask you to look at items that may have either visible or latent prints?
Well, when the vehicle was located and brought to the crime lab, it that's where I started my involvement in it. And we did we don't get a lot of vehicles in there, but when we do get them in the identification section, we sort of rotate. And I was happened to be up that time. That's how I got the vehicle.
1 second. You mentioned the vehicle. Is this the vehicle you're referring to?
Yes, it is.
And when for instance, examined the vehicle for possible prints, is that correct?
That's correct.
Did you view the vehicle once it was at the crime lab, or did you actually physically come to the crime scene to view the vehicle where it was found?
All my work was done strictly at the crime lab.
So you weren't involved in the field operations of this investigation.
No, I was not.
So now at the crime lab, you observed this vehicle. Did you observe any visible prints when you examined the vehicle?
Yes, I did.
And were you able to somehow preserve those prints?
The prints were powdered and developed that way, and then they were photographed. After I looked at the photographs and determined that they were of value for identification, then I attempted to lift them. However, for some reason or another, they did not lift real well off the vehicle.
But you did first photograph the print before attempting the lift?
That's correct.
Okay, so you were able to also do your own observation of the photograph and compare it to, let's say, for instance, a known sample.
That's correct.
In this case, do you recall what items of the RAV4 that you examined and were able to either photograph or actually lift a possible print from?
Yes, the outside of the vehicle. All those prints that I found were mostly made. Majority of them were on the rear or the side of the vehicle. Those were all powdered and then photographed, preserved that way. There wasn't other items inside the car. A water bottle. I've got a list of. I've got a list if you want to read off of the list.
If you recall,
I don't recall all the items on there, but they were processed inside the lab a little bit differently. The vehicle on the outside was processed in the garage. Obviously, I couldn't take into the crime lab area, but the vehicles that I took out, excuse me, the items that I took out of the inside of the vehicle were taken back to the lab area and placed in fuming tank. Were They were super glued and then powdered. I don't know if I don't think I had any of those photographed though, because I just lifted them.
when you examined the exterior of the vehicle, in doing so, did you look at what would be considered obvious points of potential entry, that might leave a visible or latent print?
Well, obviously, we look at the door handles and areas that like that to see if we can develop prints. I didn't see any visible in those areas except for the back door. Of course, the whole vehicle itself was powdered because not all the prints would be visible to the naked eye. The ones that were visible appeared like they been lifted in some type of a substance, whether it been greasy or something, because I think that the reason they wouldn't lift, it actually dried on the vehicle and I couldn't lift anything off of it.
Before I leave this exhibit, specifically on the back of the RAV4, you can't see very clearly in this picture, but do you recall there's a spare tire or some sort of tire on the back end?
That's correct. There is, or there
And
was.
there's a cover, some sort of cover on that.
That's correct.
Did you note any what appeared to be a swipe mark or some sort of a hand, palm print type of marking?
It actually appeared to be a whole handprint on the tire cover itself. The problem with that is, like I was saying before, this was really dirty. The back of the tire cover was, and rather than actually leaving ridge detail behind, that's actually a blank spot where they lifted the dirt off of where it probably adhered to their fingers. They removed their hands. I did take a cover off and fume it in an attempt to get other prints off it, but nothing developed. As I said, it was very dirty, and dirt is not the good medium for fingerprints.
So you attempted to actually lift a print off of it, unable to do so.
I didn't attempt to lift in using lifting tape. I attempted to develop one. There was nothing to develop, so there was nothing to lift.
From the photograph you took of that, you didn't. I'm sorry. You did take a photograph as well.
The photographs were actually taken by Brian Werner, who is a forensic photographer at the lab. But yes, I had him photograph it first.
And you had an opportunity to review the photograph too.
Yes, I did.
Were you able to find any sort of ridge formations? Were you able to provide any sort of a comparison from?
There was no ridge detail on the back of the tire cover that was suitable for comparison.
Were there any what appeared to be clear indications of a hand or palm print on any other vehicle parts of the exterior of the vehicle?
Yes, there was. The other palm print was on the rear of the vehicle. It's actually on the side rear. I think it was the driver's side near quarter panel, almost right close to the back door.
By pointing to this area, would be in this area on this picture.
Right, yeah.
And again, was it your ability to, were you able to photograph that apparent palm or handprint?
Yes, we were.
Were you able to extract any sort of physical print from that?
Yes, we were.
And were you able to match that to any known sample that was provided to you?
No, I was not.
Now, specifically, in this case, you were provided with the number of family members of the Avery family, correct?
That's correct.
And at one point, you were provided with Brendan Dassey's, I believe it was fingerprints and palm print.
That's correct, I was.
Were you able to compare, or did you do a comparison of that print from the side of the vehicle with the known print from Brendan Dassey?
Yes, I did.
Were you able to make a match?
No, I was not.
I'm going to show you what's been marked, and that last one, by the way, for the record, was Exhibit 141. I show you what's been marked as Exhibit 144. You had mentioned that in the interior of the vehicle there were some items that you attempted to lift the prints from. May have actually done so, correct?
That's correct.
If you can see, I'll provide you with a pointer.
Okay.
Do you see any items on the interior of the vehicle that you were able to obtain some comparable prints from?
I believe that's a water bottle right in there. I known of, and another one right there. Possibly, I think we're the total of 3 water bottles, and I did get some prints off of either 1 or 2 of those that I was able to lift.
Were you able to obtain any usable prints from the black CD case?
I'm going to have to refer to my notes if you don't mind.
That's fine.
Yes, I was.
So can you tell from your notes then what exactly from the interior of the vehicle you were able to extract a usable or comparable print?
Yes, from my notes. Well, from my report, I was able to get off of about 5 different items in the vehicle. For one, there was a crunchy granola wrapper that I was able to get a latent print off of that was suitable. One of the Aqua Fina water bottles that were in there, and black CD case, which is right there, and another partially full bottle of Aqua Fina water.
And from these items from the interior of the vehicle, were you able to match with any of the known samples provided to you during this investigation?
No, I was not.
And specifically, later, you were provided with Brendan Dassey's prints. Again, palm prints and fingerprints.
That's correct.
Were you able to match anything from those interior items with the known sample from Brendan Dassey?
No, I was not.
Do you recall at any time during this investigation when you were asked to assist law enforcement? Were you ever asked to examine and determine if there were any prints on shell casings?
No, I was not.
So, if I were to show you a box of shell casings, you would never have looked at those, correct?
No,
So, you would have no idea if there were any available prints, either latent or otherwise, that could be drawn from those casings.
no.
I'm going to show you what's been marked Exhibit 82 on the big screen. And do you recall at any time during your involvement in the investigation having an opportunity to examine and determine if there were any usable prints from the items that's on the screen?
Yes, the headboard was submitted to the lab and I processed that. And I was able to develop one print suitable for comparison and identified that one as being to Stephen Avery.
So that was the only print that you were able to find?
That's correct.
I'm going to show you what's been marked as Exhibit 107. Do you recall at any time during your involvement in this investigation being provided with this blackjack creeper in the middle of the picture?
No, I was not.
So, if there were any prints, you wouldn't be able to tell us whether or not there were any there, correct?
No, I never examined that item.
Do you recall specifically what items were actually provided to you to look at?
The only other one that was provided to me that I didn't collect myself, I believe, was the headboard.
So, no leg irons or handcuffs were provided to you?
No, they were not.
The gun itself was not provided to you
No,
to look at?
no, it was not.
This bleach bottle here.
No,
Okay, I suppose I could go through each item of evidence with you, and the answer would be you didn't look at anything else other than what you've already testified to,
That's correct.
and no known or no prints matched Brendan Dassey, correct?
No, they did not.
Okay, I have nothing else, Judge. Thank you.
Cross.
Thank you, Judge. Do you do anything in DNA lifting prints around the state for any law enforcement agencies?
I do training in the evidence tech school. At times, I'll go in there and teach latent print comparison and latent print development.
And when you teach at the tech, the evidence technician schools, do you teach them which services are more amenable to getting prints from than others?
Yes, I do. I give them my experience as far as what I have and have not been able to get prints from in the past.
And do you believe that the evidence technicians, after attending that training, are capable of making those decisions on what to send to for possible print analysis?
I would assume so, yes.
Could you tell a juror some of the factors that play into whether a service might be a good service to capture a fingerprint?
Well, actually, it depends on two things. It depends upon the surface, and it also depends on the nature of the person's skin. Some people with normally very dry hands don't leave a lot of fingerprints, or if they have any rough hands, let's say they're a construction worker or a brick mason or something, that's going to endure and wear down the fingerprints. They leave very bad impressions. The best surfaces that we have to develop prints off would be something that's very smooth, such as glass. Vehicle inside was was a good medium for that. The headboard, I was lucky to get a print. Wood items usually don't do well. Uh, very small items are difficult because they don't leave enough of fingerprint pattern on them to be able to identify. We get syringes in all the time, and they want to get the top of the syringe to see if we can develop prints from those, and I have, but there's just not enough individual characteristics to put in that pattern area to be able to identify the print.
I'm going to ask Detective Wiegert to just bring you up one of our exhibits that Mr. Fremgen talked to you about, and what exhibit 128. And I'd ask you to just look at these are shell casings which were recovered from the garage of Stephen Avery. Could you talk to the jurors a little bit about your opinion on the chances of getting fingerprints from an item that size, and explain the factors involved in that?
I suppose it's possible. I have probably processed over 1,000 of these, and not one time have I ever gotten a fingerprint suitable for comparison. The best I've even been able to do is maybe get a little bit of a ridge detail on there, but it wouldn't be enough to for an identification at all. Another factor involved when these are shot, they get hot, and the heat isn't very good on a fingerprint either. So you have two factors going against them. One, the size of it, and two, what the heat does to a fingerprint.
And are these examples of your experiences that you teach evidence technicians when you go to technical schools and teach?
Yes, they are.
And this is what the evidence technicians at the local law enforcement agencies learn from you.
Well, either from me or whoever happens to be teaching the class at the time, yes.
And they therefore are capable of making decisions on what to send forward to the crime lab for analysis.
Yes, they are.
Can fingerprints prints be cleaned off of an object or wiped off?
Oh, most assuredly, they very fragile. They're made 98.5% water. So wiping them off, it would be very easy.
And when you examined the RAV4, trace a hotbox RAV4, did you yourself do the inventory of those items that you found in the RAV4?
Yes, I did.
And did you know that it was Teresa Hallbach's RAV4?
Yes, I did.
And the fingerprints that you found identifiable prints, I believe. You testified on 2 water bottles. Is that correct?
That's correct.
A CD case
That's correct.
and a granola wrapper.
That's correct.
And could those items that were very well could have belonged to Teresa Hallbach?
I suppose so, yes.
And she would have handled those.
That's correct.
But did you have samples of Teresa Hallbach to compare?
No, I did not. She had no record on file.
Did does a time ever come when you make decisions on whether to examine something for a fingerprint, or maybe send it for a DNA analysis first, or maybe do a DNA first and some other tests second? Do those questions come up?
It comes up all the time, yes.
Are you aware that do you know who Sherry Culhane is?
Yes, I do. She's the section head of our DNA section.
And when you did the inventory of the RAV4, I'm sure did you observe there was blood stains and blood stain patterns in that RAV4?
Yes, I did.
And do you know whether Sherry Culhane tested those blood stain patterns?
Yes, she did.
Now, do you know whether she determined whether the blood of Stephen Avery was found in that RAV4?
Yes, I do. I've seen her report. There was his blood in there.
And Nick Stockey of your office also issued a report that the bloodstain patterns found he found were indicative of an actively bleeding person, correct?
That's correct.
So is it fair to assume that Stephen Avery was inside that RAV4?
I believe so, yes.
Did you find his fingerprints in the RAV4?
No, I did not.
So the absence of someone's fingerprints does not mean that person was not at the crime scene at all.
Not at all.
Thank you, sir. That's all I have.
Any redirect, counsel?
Just a few. Excuse me. Just a few. Do you know whether or not Brendan Dassey has characteristics of his hands that are dry or greasy?
I would have to examine his hands, and I couldn't tell you that.
You can certainly say, however, that as to the 3 items in the vehicle, they did not match the known sample of the fingerprint of Brendan Dassey.
No, they did not.
Now, you mentioned that often smoother surfaces are easier to either find a visible or even a latent print.
Yes, they are.
Would smooth steel handcuffs be something that might be able to extract a fingerprint from?
They could, possibly. Again, I'd have to examine the handcuffs to be able to tell you if the surface would be good enough, or if they were in good shape. There's a pretty good chance I could find them. But I've seen some of these cuffs that the finish was worn off and they were rusted. And in that situation like that, I'd be more difficult.
Would these, for instance, be something that you might be able to extract a fingerprint from?
I believe so, yes.
And I'm showing you what's been marked as Exhibit 92. It's actually crime lab number CJ-2.
Okay.
But you weren't provided with these
No.
to review.
This is the first time I've seen them.
Thank you. Nothing else.
Again, items can be cleaned or wiped off. Fingerprints wiped off or cleaned from an item.
That's correct.
Thank you. That's all I have also.
You may step down. Mr. Fremgen, any additional witnesses this afternoon?
We'll have a psychologist who's prepared to testify starting at 8:30 in the morning. Take a probably majority of tomorrow.
All right, I take it that's a no for this afternoon.
Sorry, no, for this afternoon. Correct.
All right, ladies and gentlemen, I'm going to excuse you at this time. Remember, you are not to talk about the case or anything that you've heard or anything connected with it. Thank you. Counsel, before coming out here on the record, we had a brief discussion in chamber. It is my understanding there are some matters we should make a record of this afternoon. Mr. Kratz, I'm going to turn to you first. You may or may not have a motion or an argument.
I do, Judge. If I could have just a moment to grab my materials. Thank you, Judge. As this court recalls, a motion was argued in a pre-trial manner regarding the admissibility of testimony of a Dr. Robert Gordon. Dr. Gordon provided this court through videotape testimony with something called an offer of proof, which is expected trial testimony, and based an opinion on what Dr. Gordon believed evidence at this trial was going to establish. Dr. Gordon, as this court knows, has opined in a written report and in his offer of proof that Brendan Dassey was, in fact, an individual who was using his term now vulnerable to suggestibility. The state had objected in oral argument as well as written provisions to the court to Dr. Gordon's testimony, noting that this kind of evidence has not been admitted in the state of Wisconsin, at least to this point. And whatever marginal relevance there may be is certainly outweighed by the danger of confusion of the jury or unfair prejudice. Nonetheless, the court reasoned in a pretrial decision that Dr. Gordon would be allowed to testify as to the area of suggestibility, again, based upon an offer of proof. I recall, and I'm sure the court has a recollection as to my argument, both oral and written, cautioning this court as to its pretrial ruling prior to even knowing what the trial testimony was going to be, especially as it relates to foundation or to relevance. And what I argued, Judge, was that it's going to depend on who is going to testify in this trial, that Brendan Dassey's statements were the product of suggestibility. In other words, that somebody had to come before this court and claim that Brendan Dassey's statements to law enforcement officials were, in fact, the product of law enforcement behavior, law enforcement suggestibility, or at the very least, some coercive practices by law enforcement for Dr. Gordon's testimony to ever be relevant. Relevance, of course, is well defined, and this court included that in its pretrial ruling. And I'm not going to re-argue or belabor that. I agree with the court's definition and explanation as to relevance. Now, however, we're at the point in the trial where we don't have to guess as to what the trial testimony is going to be. We don't have to call it an offer of proof anymore, or expect or presuppose what some trial testimony may be. We've now heard what the defense theory of the case is. what the defense version is, and as announced by this court and as predicted by the state in my written brief, Brendan Dassey himself has testified and has provided to the court uh, with a version of events or an explanation as to the admissions, or what we've referred to as the confession given in this case. Importantly, Judge, Mr. Dassey today, when testifying in this trial, said nothing of suggestibility, despite Mr. Fremgen's best efforts in continuing to ask Mr. Dassey about things like suggestibility. Mr. Dassey's responses, when he didn't say, I don't know, Mr. Dassey's response was something called confabulation. That is, that he made it up, that he made up the version of events that he told law enforcement officials. Confabulation is, of course, absolutely a separate concept than suggestibility. Uh, and when Mr. Dassey and the defense, through Mr. Fremgen and Mr. Edelstein, who I assume knew what Mr. Dassey was going to testify about today, present that theory of defense, and that theory is devoid of any mention of suggestibility. Well, then, Dr. Gordon's testimony just simply no longer becomes relevant. Uh, this court's pretrial order and ruling, which the state respects very much, must simply is no longer based upon what the trial evidence is in this case. When Mr. Dassey explains that the version of events given to law enforcement is the product of a fabrication, or even if we believe that it's the product of some memory several years ago of some book that he may or may not have read, it is just not suggestibility. I then, and at this time, renew my motion, ask the court to reconsider its finding as to Dr. Gordon's testimony. We're asking that Dr. Gordon's testimony be excluded. We don't believe there is any foundation in this record, nor is there any relevance to Dr. Gordon's ultimate opinion that Mr. Dassey is vulnerable to suggestibility. Now, we understand that this court has already limited Dr. Gordon's testimony. This court's already previously indicated that Dr. Gordon can't talk about whether the confession was true or false. That is, whether it was a false confession. Can't talk about a coercion or the circumstances surrounding the interrogation. And although there are experts that can talk about that, Dr. Gordon admits that he's not one of those kinds of individuals. But his testing and his opinion, as limited to suggestibility, simply is not relevant. Would ask the court revisit and exclude the testimony. Alternatively, Judge, we are asking if the court continues to allow Dr. Gordon's testimony in this case, despite the lack of foundation for his testimony. We would ask the court to reassert or restate just what it is that Dr. Gordon can testify about. Just what is relevant about Dr. Gordon's testimony based upon the record currently before this court. We certainly don't want to be in a position where we're needlessly objecting during direct examination, or that the state unnecessarily has to cross-examine Dr. Gordon on issues that may, in fact, not be allowed through this court's orders. Lastly, Judge, at the conclusion of this motion, that is, at the conclusion of to exclude, or the renewal of my motion to exclude, I would ask also to place on the record state's request to call, if necessary, rebuttal witnesses. But I have, unfortunately, gotten ahead of myself, and I'm just alerting the court that we do have that issue discussed as well. That's all the comments I have regarding Dr. Gordon's issue. Thank you, Judge.
Response?
Just a brief one. Well, I'll try to be brief. The state began its argument by indicating that they expected Dr. Gordon to testify as to what evidence would indicate in this trial. Well, I don't think that's ever been what we've offered to this court, and I'm certain that's not what the order of this court is. What we've offered previously is that the doctor would testify as to his conclusions based upon his evaluation of Brendan, his review of the collateral information, which included the videotape statement that was shown in this court, as well as other statements that had not been provided to the jury. And he would also testify as to the different tools of evaluation, the different tests that he actually conducted, and the purpose for those tests, including the Johnson suggestibility test. We intend to offer the same testimony with the same limitations that the court imposed on his testimony per the order of April 5th. The state's argument today is that there needs to be additional foundation, essentially, or that there hasn't been a sufficient foundation placed on the record for the doctor's testimony. Part of what the state argues is, well, I think maybe he misspoke, but Mr. Kratz said foundation as to suggestion or coercion. We've never once indicated that Dr. Gordon would ever testify as to any coercion. In fact, he even, in the offer of proof, said, I don't have the ability to do that, and would not offer his opinion as to the officer's techniques in regard to coercion. So that was never an option. It was never going to be something offered to the court. The indication that we provided to the court with the limitations in the order, simply that he would be testifying about the issue of suggestibility or vulnerable to suggestion, as I think he referenced in his report. So far, the testimony on direct and on cross of the defendant was that, as to many questions, he answered, I don't know why. When asked why he would admit to a serious offense, such as a sexual assault or first-degree intentional homicide, his answer is, I don't know why. I probably could count up on the transcript and come up with at least 20 or 25 times that that came out. There were times in final cross by Mr. Fallon that this idea of confabulation came up, but there's equal or more testimony in regards to why he did what he did, and his answers were, I don't know why. Our intention is to wrap up what we've started with all the witnesses, with the Officer Wiegert and with Detective O'Neill, for that matter. Attorney Edelstein's questioning of at least with Detective Wiegert, was essentially 90% suggestibility issues, promises, lies, suggestion, and leading. With Detective O'Neill, there was a number of questions about suggestion, leading, promises. In fact, the state brought up the subject when the state says there's devoid of anything in the record about suggestibility. The state, on cross of the school counselor, asked her about suggestibility, so the issue has been raised by the state as well. We would certainly object to the ruling changing the original ruling. And as far as offering to the state some sort of a roadmap of where I intend to go, or some formalized transcript of the question and answers that I intend to elicit from the doctor, I guess I would offer again, we will follow what the court ordered, the offer of proof with the limitations that this court has set upon the testimony, and as to providing to the state some sort of heads up, as so to speak, I I guess I would just mimic what the state has told me throughout this trial. I'll question my witnesses how I want without having to answer to the state. And so I would follow the order that the court placed on us. And I don't believe that there has been this lack of foundation that the state is suggesting with the court now to change the ruling before in regards to Dr. Gordon.
Mr. Kratz, any response?
I don't have any. Thank you, Judge.
All right, is both parties have noted the court has had an opportunity prior to this date to take up the issue of Dr. Gordon and any testimony that he might have to offer. The court ruled that Dr. Gordon's testimony and I did this based on a couple of things, or based on the instance of seeing a proposed offer of proof from the defense by way of DVD, and as well the testimony adduced by Mr. Kratz at a cross-examination of Dr. Gordon under Section 90702 of the Wisconsin statutes. Expert witness testimony is permitted if the preferred testimony is relevant, if it will assist the trier of fact in some way, shape, or form, if the expert is qualified, and if the testimony that's going to be offered superfluous or a waste of time. This all stems from a case called State versus Wallstead at 119 Wisconsin 2D 483. I found initially that all of these qualifications were met. There also is a secondary line of reasoning that can occasionally be employed, namely that by virtue of the Sixth Amendment of the U.S. Constitution and Article 1, Section 7 of the Wisconsin Constitution, a defendant should have the right to present a defense. And while I didn't make a finding directly on that point, I think I alluded to it at least collaterally in arriving at that ruling. Mr. Kratz says, in effect, that based on the testimony offered by this defendant in person today, that the foundation for any kind of testimony from Dr. Gordon with respect to suggestibility is, in effect, potated, that is to say, taken away. His testimony, Dr. Gordon's testimony, no longer becomes relevant, and thus it misses on the first step to the first prong of a test of whether or not it should be used in this case. I'm not going to recede from the ruling that I handed down before. I think what we have at best today is testimony that doesn't go to the admissibility of anything Dr. Gordon has to say. And again, what Dr. Gordon is, as I understand it, going to testify to that based on a number of tests that he administered, this defendant, based on the age of the defendant, based on the defendant's limited cognitive abilities, that this defendant falls in the category that scientifically has been proven, judged as being a category of persons being more suggestible or vulnerable to saying things that aren't necessarily true. I think Dr. Gordon's testimony is still relevant. I think that he is a qualified expert. I think that his familiarity with the Johnson suggestibility scale and the other tests that were given to support whatever opinion he's going to give are all as good today as they were before. Now, with that said, it may be again that while his testimony is, I believe, admissible, it is up to the jury as to what weight that testimony should give. They are the persons that determine the weight. I also find that I do not believe, based on anything I've heard today or during the course of a trial, that his testimony would be superfluous. Accordingly, I'm going to deny the state's motion to exclude his testimony.
Judge, I don't mean to take issue with the court. You mentioned that the doctor would testify to being vulnerable, to saying things that weren't necessarily true. I think that's exactly what the court said he could not testify about. He's vulnerable to suggestibility. But whether it's true or not true is something this doctor cannot testify.
Right, and I did say that, and thank you. I'll sharpen that up. He can't testify As to what this defendant said as to whether it was true or false, he can testify as to the suggestibility or the vulnerability based on the factors, but he cannot utter an opinion as to the truthfulness or falsity of anything this defendant said.
Thank you, Judge. And as to my second purpose for alerting the court as to the state's intent with this court reaffirming its ruling, the state does intend to and does offer at this time two rebuttal witnesses. One is a clinical psychologist who will directly rebut Dr. Gordon's testimony as to the testing, IQ, and what opinions may be drawn therefrom. His name is Dr. James Armentrout. We previously, meaning earlier today, I don't mean to indicate, because of the rebuttal nature, that it was other than today, but informed defense counsel of our intent to call Dr. Armentrout as a rebuttal witness. But secondly, Judge, and something that we have alerted the court and counsel to earlier, was our intent to call an expert in the area as to the interrogative process. This court may recall, as part of Dr. Gordon's offer of proof, Dr. Gordon indicated that he was not an expert on issues of interrogation strategy or circumstance, but that such experts do exist. Dr. Gordon conceded that fact to both in court and on his DVDs. The suggestion and the effect of the matter is then, as to the area of suggestibility, there is a prong, if you will, as to the testing and the IQ and the age and the vulnerability to suggestibility that psychologists talk about. But the other part of that Dr. Gordon talked about was the circumstances surrounding the interrogation, the strategies, and the like that were employed, and what after reviewing a specific interrogation, what opinions can be drawn therefrom. State intends, as the defense and the court know, to call a Mr. Joseph Buckley, the president, as I believe, of Reed and Associates, author and expert on issues of the interrogative process. With the court having reaffirmed this ruling, we simply offer that. If the court needs or the court wishes some further offer of proof or sharpening of that Mr. Buckley's relevance or his intended testimony, we can certainly do that. A report has been tendered to the court and to the defense as to Mr. Buckley's intended testimony. If I could have just a moment here, Judge. And Judge, you may want to just take judicial notice of the report of Mr. Buckley that has been provided to the court, should Mr. Buckley's testimony be allowed. We'll certainly have that marked as the trial exhibit and will be officially offered at that time. That's all I have as to, again, just by way of alerting the court and counsel as to the state's intended rebuttal case. Thank you.
All right. Does the defense wish to be heard on this now? Rebuttal, of course, is at the discretion of the court, and it may be you want to wait until you hear what Dr. Gordon has to say, although I suspect Mr. Buckley's rebuttal may have as much to do with the cross-examination of Investigator Wiegert as it does anything that Dr. Gordon may say.
Up to the court. I don't think that Dr. Gordon's testimony necessarily is going to be indicative of what our position is, Mr. Meade, or Buckley. I'm sorry, Mr. Buckley.
Yeah.
Are essentially, and let me first answer the first comment about Dr. Armentrout. The only thing I would ask from the state, if at the time he testifies, if there is any sort of summary of his impressions laid to some written form, that we be provided a copy prior to his testimony, whether that be the second he sits down. However the state wishes to provide it would be great. Also a CV. I mean, we provided our curriculum vitae of our doctor. If we could have Dr. Armentrout's sometime before he testifies, we would appreciate that as well. However, as to Mr. Buckley, we have three essential positions as to why we don't think it's relevant. Number one, it's not a unique subject that this trier of fact, the jury, needs assistance to understand. In fact, they've had two witnesses already talk about it, both detectives. Detective O'Neill and Investigator Wiegert have testified that they are trained in deceptive practices. Superior knowledge, whatever language is used to explain why they lied, promised, led, or suggest to a interviewee in order to get information or extract information they want. So it's it's a point. I won't say necessarily cumulative, but it certainly has been developed and addressed by the state. It also seems to be somewhat of a vouching of the state's witness. Officer, Mr. Buckley would be testifying essentially that the officer's testimony, that this is how we're trained, and this is just simply an interview technique, would be an offer to simply vouch for the veracity of the officer's testimony in that regard. And we also believe that there are some comments in that report about what is corroborated and what is not, that impedes and infringes upon what this jury's role is. And the attorneys can certainly suggest to the jury, this is corroborated and this is uncorroborated. And that's fine. But I think it's different having a witness get up there and say, I've reviewed what the police officers did in this case, and let me tell you, jury, this is what they did right, and this is what they found, and this is why you can find this person guilty. I don't think that is the role of an expert. Experts should be offering some sort of testimony that, number one, has to be relevant to some sort of material issue, which we don't think necessarily is that there is enough with this offer as of yet. And number two, we certainly have to say there is nothing that indicates that this trier of fact needs assistance to understand that. In fact, I believe in opening, Mr. Kratz mentioned to the jury comments about officers questioning and why people don't admit to things that they didn't do, especially as serious as homicide, because it's just human nature. You all understand that, quote unquote. That was what Mr. Kratz said to the jury. Well, if they understand it, then why do they need an expert? So I don't think it's necessary.
All right, Mr. Kratz, getting to you with respect to Dr. Armentrout, counsel was asking for a copy of his CV and as well any sort of summary that you might be able to supply, even if it's at the 11th hour. Are you able to accommodate him on both those counts?
Well, Judge, there is no written report. There is no summary. Dr. Armentrout's opinions will be based solely and entirely upon what's been provided by Dr. Gordon. So the materials that Dr. Armentrout will be drawing from, they already have. The CV is something that I will ask to be faxed, and we'll try to get that here, Judge, and accommodate out of courtesy to the defense. Did you ask me something else?
I've forgotten. Then I'll be quiet.
No, well, we'll get to the issue of what, if anything, Mr. Buckley can testify to based on, in part, what we hear tomorrow, and in part, I want to review the report again. Report was handed, I believe. I got it on Friday from the state.
Might I suggest, Judge, that on Wednesday we might convene in court, perhaps at 8 a.m. and get some direction. We expect Mr. Buckley to testify in the morning, and I think that is probably appropriate that everybody, not just the state, but that the defense has fair notice about the scope of what he'll be allowed to testify about.
That's fine.
Thank you.
Any other matters today?
Nothing for today. Thank you, Judge.
All right. I'll see you tomorrow, 8:30.